in the matter of the marriage of Brian Boyer versus Melissa, now known as Beasley. I'm going to cross out all the attorneys here because there are no attorneys involved in this case. Both attorneys previously entered in the case. Joshua Andrews, on behalf of Brian Boyer, has withdrawn. Marlo Hamrick with legal aid on behalf of Melissa Beasley has withdrawn. So today, both parties are self-represented. This was scheduled by my administrative assistant as a status of both parties' motions. They were not filed simultaneously, but relatively close in time. To determine whether or not the parties are retaining attorneys. And as I've indicated, none have entered on either party's behalf. And also to verify service, as the petitioner's motion to enforce visitation and the respondent's motion to modify visitation were both filed pro se without immediate request for hearing or return of service. Now, my understanding is that at the last conference, my AA inquired about service, and since that time, Ms. Beasley or a return of service has been filed with regard to Ms. Beasley. First of all, Ms. Beasley, you've accepted service of his motion to enforce visitation, and you've gotten a copy of that, correct?
Yes.
And I don't see that you have a return of service for your motion to modify. But Mr. Boyer, have you seen that motion to modify visitation and accept service of that?
No, I have not.
Okay. I understood that you were both directed to serve your motions upon each other by certified mail or some other form of service.
Yes.
Okay. Well, that motion is on file. You're going to have to seek a copy from the clerk, or I would suggest, Ms. Beasley, that you send a copy by registered mail and file the certificate of service in the court file to prove that you provided him with a copy, gave him notice.
Okay.
With the motion. All right. Now, Mr. Boyer, who do you have with you?
My now wife,
Okay. And what is her name?
Para Boyer.
All right. This is a 2017 case, so it's an older case. Originally, there were two minor children that were the children of the marriage when you got divorced, and that was Cheyenne and Chloe. Chloe has aged out because she turned 18, correct?
Right.
Yes.
Okay. So the only child at issue is Cheyenne. She was born in 2012, and so she's about 13, correct?
Yes.
Okay. Now, when I look back at the file, what I'm showing, which I have to go to the very last court order because it controls the case, the last court order that was entered. And what I ascertained was that on January 30th of 2019, you guys received a divorce. There was a decree of divorce. There was also a parenting plan that was filed and a supplemental holiday plan, and that was the last order that was entered by the court, and it gave dad primary residential custody of the girls. And again, we're only talking about Cheyenne now. She's the only remaining minor of the parenting plan. Mom got first and third weekends, 5 p.m. Friday to 5 p.m. Sunday. Fourth weekend, Friday to Saturday. I think it was 5 to 5, but it wasn't a full weekend. And then she was awarded winter break, spring break, and summer, where then you got the same coordinating weekends. So you flipped that when she had summer custody. Then on 7/23 of 25, dad filed a motion to enforce visitation because he claimed that Cheyenne was not returned after summer visitation. She was enrolled in school in Douglas, where mom currently lives, instead of Eureka, where father lives, where he, as the primary residential parent, had her enrolled in school. Service wasn't obtained, a hearing wasn't requested, one wasn't scheduled. In the interim, a motion to modify visitation was filed by Melissa on 8/6 of 25. Again, no service, no request for a hearing date to give notice of hearing. And it was alleged there that the child did not want to return to dad and that mother could not physically force her to return. And so here we are. There was a hearing on 9/30 by notice of our court because nothing had been scheduled to get this thing up off the ground. It is a serious situation, but as I indicated, all of the procedures have to be followed. But we did want to get you together to recognize that these motions are on file. They're conflicting motions, and get this thing scheduled for a full evidentiary hearing if necessary. Additionally, mom asked that the child be heard, that the child wanted to communicate with the court. Now, please understand, there is no age in which a child can make their own decision. The court does often hear from a child or children. Generally, I never want the first recourse to be testimony or involvement in the litigation. But I am allowed in chambers to visit with children by agreement. If one party wants it recorded, it has to be recorded. That is not, again, my first avenue. My first avenue is generally to have a child with a school counselor, a therapist, or an advocate who the child is entrusted to, that provides information to the court, not only about the child's wishes, but what that person sees in terms of the best interest. I mean, that person reconfirms for me that the child is mature for their age, that the child is taking a position for the right reasons. That is quite helpful to the court.
And Cheyenne has been seeing the school counselor.
Okay. but I am, you know, noting that for you in terms of I'm acknowledging that mom has asserted that she has an opinion about where she goes to school and who she wants to live with during the school year. So, having said that, I'm probably going to, well, I want to hear from both of you as to your position on the record under oath. And so we'll go from there, but probably the result today is going to be that I make enter a temporary order and schedule the matter for a full evidentiary hearing in person to make a final determination. The preferred route for these things is that the child should have went home under the current order, and mom, you should have filed a motion during the summer before school started to, one, give you custody of the child for the school year, to change physical custody for the school year, and to give permission to enroll her in the school instead of not following the court order, keeping the child, making him file a motion to enforce. Now I'm put in a position of, one, starting with the premise that you violated a court order, but two, having to consider yanking a child out of school that a parent has put the child in school in violation of the court order. So I have to take all of those things into consideration and try to straighten this out and provide the least amount of disruption to the child and her life, but also act in her best interest with what little information that I have. Okay, so since the motion to enforce was filed first, I'm going to have Mr. Boyer, you go first. And if you'll raise your right hand, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Okay. Now, normally, thank you, in a court proceeding, there is an attorney who asks questions and an attorney or a party that can object to questions for various legal reasons. But because you're acting as your own attorney and you're a witness because you're a party, then there isn't a lot of latitude for the court to follow evidentiary rules as it relates to testimony. So if during the course of things, one or the other of you has an objection about particular testimony, you need to, in a orderly way, advise the court that you're objecting so that we can try to address it as best we can, given the nature of a self-represented proceeding. So, Mr. Boyer, you need to state your name and what statements you wish to give under oath with regard to Cheyenne not being returned to your care at the end of summer for the beginning of the school year.
Well, the last time I seen Cheyenne,
Okay.
oh, Brian Boyer,
All right.
and last time I seen Cheyenne at my house was Wednesday, June 11th. Her mother come and picked her up from my house, and that was the last time I seen her. I was refused my Father's Day parenting time. all my weekends since then, I have not got. Cheyenne got to miss out on vacation trip to Branson with us because
Okay, hang on, ma'am. You're gonna have to sit back on the couch and observe. You can't keep telling him what to say. Please, I'm sorry. Thank you. All right. Go ahead. What about your weekends?
I have not got any of my parenting time since then at
Okay, so
all.
what have you done to try to facilitate getting the child or enforcing the court order?
Well, for one, when she moved to Douglas, I do not have an address where my child's at. I have no clue. All I know is she lives in Douglas, which it states in our papers too that if we move, you got to give a 30-day notice on a new address change. I haven't got one.
Okay. So what you're telling the court is you had no place to drive to.
I have no clue where my daughter is at other
Okay.
than Douglas.
And did you contact the Douglas authorities, whether it's the sheriff's office or I don't think they have a police department, frankly, but
Yes, I talked to the sheriff on July 23rd about this.
I'm sorry. I may have interrupted you. I apologize. I couldn't hear you. Go ahead.
On July 23rd, I contacted the deputy that patrols down there, and we had a conversation on what to do. And basically, he told me to call her in as a runaway, but that goes on her permanent record, and I really didn't want that on my daughter's record.
Okay. Did he try to locate where she was living, where mom was at?
No, because don't know.
Did you, does she have her own cell phone?
Yes, but it is highly monitored by her mother. Every time I try to call her, you hear it click on record.
Okay, so did you talk to your daughter on the phone after June 11th about where she was at, where her mom was living, what residence she was at?
All they've told me is she lives in Douglas. They won't give me an address.
So how many conversations on the phone did you have with your daughter?
I've had probably 3 good conversations and a few text messages, Snapchats, but other than that, my daughter really doesn't talk to me anymore.
Well, what did she say to you during those discussions about weekends with you and that kind of thing?
Well, just our prior court date on the 28th of August, that evening, Cheyenne called me and she stated to me that she wanted to come back to Eureka. She misses all of her friends. She wanted to come home. And that's multiple times that I've heard that from her. I've got a text or a Snapchat from her sister where she thinks that she blew this out of proportion and went too far with all this. So Cheyenne's recognized what she's done. And I just want my daughter home.
What are you talking about, a child support enforcement action that was going on?
No.
Okay. All right. So on August 28th, she told you that she wanted to come home and go to school in Eureka?
Yeah, and missed all of her friends.
Okay. And when did school start in Eureka?
Well, it had been the 17th, I think it was. 21st. 21st, yeah.
Okay, so this was already past school having started in Eureka.
Mm-hmm.
Did you enroll her in school in Eureka?
Eureka wouldn't let me because Melissa had already enrolled her in Douglas without telling me that she's enrolling her in Douglas.
How would they have known that she was enrolled in Douglas?
Because Douglas School District contacted Eureka to get her transcripts from Eureka. Because Cheyenne's been in Eureka since she started school. She started preschool here.
Well, I think I would have shown, I would have went to Douglas High School and shown them the court order. So you never physically tried to go pick up your daughter at school or anywhere?
No, not yet. I actually faxed the court order down to Douglas, and he said I had no justification because of the wording of it.
Well, I mean, no court orders generally give precise dates each year, but when summer's over, that means the school year started and you clearly had primary residential custody under those orders.
Yes.
So. All right. And so when is the last time that you have spoken with your daughter?
It would have been a week and a half ago, probably.
And what did she tell you?
We just carried on a decent conversation, and once again, she mentioned that she wanted to come home and she missed all her friends.
So, have you checked with Douglas? Are you able to get into Power School or whatever they offer to see what her attendance is and how her grades are and that kind of thing?
Yes, we can.
Have you done that?
Yes, I had called down there and get access to all that.
All right. All right. What else do you want to tell me?
I think that's about it.
Have you been receiving your child support from Melissa?
Yes, I have. And just to note, she is, last I checked, she's like $3,500 in the hole in rear.
Okay. All right. Give me one moment. And then Melissa, I'm gonna swear you in and hear from you.
Yes, ma'am.
I wanted to clarify on the record. I'm trying to figure out when you said you talked to her before the August 28th hearing.
Yes, I had my date wrong. That was this last court that we just had a week and a half ago.
Okay. Well, our records indicate, and Amy, you could correct me if I'm wrong, that on 8/28, Amy scheduled the 9/29 hearing, which was the status with her as to service and whether or not you were retaining attorneys.
Yes.
And then she scheduled our hearing today for me to be involved. But you did have a child support hearing on 9/19 that was continued to 11/21 because of our hearing today.
Yes.
Okay. All right. All right. Melissa, if you'll raise your right hand, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, please state your name.
My name is Melissa Beasley.
Melissa, are you remarried?
I am.
Okay. And what is your spouse's name?
Christopher Beasley.
Now, I understand you filed a motion for modification on 8/6/25.
Yes, I was having problems filling out my paperwork, so I had to keep doing it. That's my bad.
Okay, well, what's going on? I mean, why are we not following the court orders?
So that Tuesday when I picked Cheyenne up from Eureka and we were driving back, she was crying and upset. And she asked me to get residential custody because they both drink and she didn't want to be there. So I encouraged her to go to her dad's weekends and she always refused. Um, I have sent Tara and Brian both my new addresses in Douglas, and I have those text messages. Cheyenne has gone to Eureka schools her whole life. And for an 8th grade girl who is 13 to ask to be removed from her school that she's familiar with to go to a new school, there's a bigger picture. And she is in counseling, and I'm trying to help her. I'm trying to be her voice. And I have voiced with Brian, and I have copies of them text messages too. I said, I do not want to take our daughter from you. I want the best for her. And right now she's going through some stuff because of their drinking. um, and she did call him the other day, and I did record that phone call. And she did say she missed her friends in Eureka, but she wanted him to quit drinking. And he said he would put the bottle down if it meant getting her back. And I have that all recorded. Um, I want him to find peace, and I want us to co-parent and raise a stable daughter. And it was not a stable environment. So when she asked me to do something, I did it. And was it right? Probably not. But as a mother, you'll do anything for your child. And I have talked to Brian several times and told him she is hurting right now. I do not want to remove her from his life. I don't. But the co-parenting wasn't happening. I would drive her to El Dorado or drive to El Dorado to pick her up on the weekends, and then he would make me drive all the way to Eureka. There was no compromise on travel. It was his way or no way at all.
I didn't have an
I,
address.
I have a text message between me and Tara, his wife, stating my address.
Okay, well, you guys need to look at your court order. I'm not gonna spend a lot of time on this. The court orders specifically say how transportation's to be conducted. You have to follow it unless you come to court and get it changed. The court order has specific requirements. They're set out by statute. They're not just court order. They're statutorily adopted.
He
that you
refused to
have
drive to Eureka.
In writing, you have to send it in.
Okay.
It's very specific. It tells you how many days and what you have to do. It's in your court order. So you've got to do that. Then I don't have to worry about whether a text message went through or who the text message went to. And you are not in any trouble because you've complied with the law and the court order. The same thing with exchanges and travel. Now, does she or does she not want to go back to Eureka?
No, she does not. She's very happy in Douglas. She has straight A's. She's on the volleyball team, varsity. They're doing great playing. She's thriving here. And then she is in some counseling. And I
Who is she in
encourage,
counseling with? Who is she?
she's talking to the school counselor right now. We just started her Blue Cross and Blue Shield insurance. So I'm in the process of finding an outside counselor. But we just got her off of state insurance, and she's on my husband's Blue Cross and Blue Shield insurance. So when that transition happened, I'm trying to find a counselor for her. She is
Do you
hurting.
have a letter or anything from the school counselor?
I can get one. I wasn't aware of anything that you needed, but that would not be a problem.
Can you understand why I can't have each parent representing what she says or how she feels or
Absolutely.
what
And that's why
going through?
yes.
That it has to be through a neutral party that's best for me to rely on. With the neutral party, especially when there are allegations of drug abuse or alcohol abuse or mistreatment. Those are pretty serious things that a counselor gets involved with, and they're mandatory reporters. So if they believe the child is at risk, they are required to report that to DCF or the authorities. So, yes, I need something until I can get with a full-time therapist or get a chance for her to come into my office and go through the proper steps to visit with her about what's going on. Okay, so she's a ninth grader.
He's in 8th grade.
How's she on varsity in 8th grade?
Varsity middle school volleyball. She's 18.
Oh, okay,
18, yeah, 18.
okay.
And we play in Belle Plaine tomorrow. And I've given Brian that schedule, and he's been to one volleyball game, and he's refused to go on to the rest, which is, it upsets her. She thinks her dad doesn't love her. So it's hard.
Well, I do believe he does, because he was the first one to file something to get recognized by the court that he wanted her to return. And I don't have any reason to doubt that he does love her very.
Me neither. I'm just telling you how she feels. That's why I wanted her to speak to somebody or you, so she can tell. She wants to have a voice in this.
Well, I understand. But you're the adult and you have to.
Yes.
All right. Tell me quickly what Chloe is doing, because Dad has had primary residential custody since those kids were 10 and 5.
Yes.
Yeah. Chloe is a graduated high school student with a certified CMA, CNA. She has purchased her own house in Wichita. She got her own car. She graduated with 3.5 from Eureka High School.
Okay. Is she single?
No, she's fixing to.
She's getting married in 2 weeks.
Okay.
With her high school boyfriend of
4 years.
5, 6 years, whatever.
Does she, any children?
No.
Okay, great. Does she see both of you regularly, or talk on the phone, or communicate with both of you?
We
Yes,
have family dinner. Oh, sorry.
Hang on. I'll just, Brian, go ahead.
I talk to her every day, and I just saw her, that'd have been Friday at my mom's house.
Okay. Mom, what's your relationship with her?
She comes over every Sunday for family dinner and game night.
Perfect. So it sounds like you did a good job with her.
Very proud of her.
Good. So there's no reason you can't do a good job with Chloe. And get her to the same point in life.
Yes.
Absolutely.
All right. Well, at least we have a strong base there. It's fallen apart here recently, but you guys are doing something right, both of you. All right. So first of all, Brian.
Yes. You
have a right to bring a contempt citation if you want her found in contempt for violating the court order, and you want to pursue any sanctions, but there's quite a bit to that. You'll have to file an affidavit that you do under oath. You have to file it with the court in a motion in contempt and citation to appear, for her to appear personally in court, in person. You have to get a court date in advance for that. You have to put that in the order, and then you have to have her personally served. She has to have personal service. If
Okay.
someone doesn't appear on an order to appear in a citation and contempt, then, and they've been personally served, the court can issue a warrant to have them picked up and brought before the court on a contempt citation. Now, that is an avenue that can be pursued by an attorney or by an individual if there is a clear-cut violation of a court order. But that is, I cannot do anything with regard to sanctions or anything today without that proceeding being in place. So what I'm looking at now is your two corresponding motions that were filed within a month of each other. And I'm looking at the reality of the situation right now, which is we are within reach of the first semester, I think. It's usually sometime in mid-October.
We have parent-teacher conferences on Friday, so yes.
So, I frankly have two choices, Brian. I can order that she be returned to you temporarily until we can have a full custody hearing at semester. I'm not going to take her out of school or at, the first semester. I'm not going to take her out and put her in another school unless it's semester, first, second semester, or the end of the first and second. So I'm talking about right now or December, one or the other. But my preference would be to, if she's doing well in Douglas, and I tell you what, Mom, if I find out that you have conjured all of this up,
No, ma'am.
that there is no basis whatsoever for the child to be reluctant to go home, other than she just
No, ma'am.
decided she wanted to do something different. In other words, if there are no issues at all at home and you conjured this up and did this in violation of court order, I'm not going to be very happy.
No, ma'am. I promise I did not.
This
All
all
right.
started because of the child support hearing. As soon as that happened is when all this went to crap.
She was
Well-
with me before that.
Well, what's going on with the child support? Why are there even being hearings?
He wanted
Because I
16.
filed a motion to modify child support because the girls have been coming home talking about how their mother's making all this big money. Well, her child support was based off of a previous job. So I filed for the motion to modify it.
Well, that shouldn't come into any play at all in terms of what's the child's best interest.
Correct.
So, I think what I'm going to do, Dad, is that I am going to order that until the end of the second semester, she stay at Douglas. I will make a decision by December before the next beginning of the third semester as to where she's going to permanently go. But I am going to leave her at Douglas, but I am going to require that she do those weekend visits with you. Until then, and that you not consume any alcohol during those visits, just to be on the safe side. I don't know if any of it's true, not true, I don't know, but it's pretty easy. And honestly, it's fairly common to order that when parents have primary control of the child in custody, that they not become intoxicated at least. But in this case, I'm going to say not drink, because if there was an emergency or something, you need to be able to drive them to the emergency room. You need to go pick them up from a friend's or school or whatever's going on. So it's not, I'm not assuming that you're guilty of anything. I'm just going to ask you not to consume alcohol on your weekends that you have her. And I will get to the bottom of this by doing a full trial with an evidentiary hearing. And it has to involve a therapist and the school counselor. So you're gonna have to make sure that you've got letters or them lined up to testify at the evidentiary hearing. And I will even speak to her,
I greatly appreciate
either
that.
before or after that hearing. I'm not sure which at this point. I will even speak to her as well if I need to. But mom, she needs to be told if she doesn't go to dad's on the weekend, then she's gonna end up having to go back based on the court order that was in existence at the time that she came to stay with
Absolutely.
you. So
Okay.
that is the alternative. She needs to have a relationship with both parents. She needs time with both parents. Whatever that looks like, you've been doing this weekend and switching in the summer and during breaks, and you've been doing this for a long time. So that needs to continue for dad. And if it can't, then we'll just have to go back to the way it was. And then I'll make a final decision in December based on all of the evidence that I have. But they're going to still need income information, run a child support worksheet, see what the payment should be, and have that stuff ready. Because you're gonna have to owe it until it gets changed. If it gets changed. So those are just numbers, and it's pretty easy for them to figure all of that out and have that ready. Okay, so is there any questions about what we're doing?
No, ma'am.
And as I indicated, you have a right to file a contempt. And if come to find out during that proceeding, there are things that are totally untrue, like there was never any text, mom's been hiding her out, mom's been hiding, she was taken, all of that kind of thing. You want to pursue that, and if that is true, then that can result in even something contrary to what I have ordered today. But for now, I'm entering the temporary order that I indicated to you, and I'm scheduling this for trial. Okay?
Yes.
All right. And that will be to correspond with the school year.
I'm
Now,
working on obtaining an attorney. Is that okay?
This is a Butler County case, but you live in Greenwood, Brian, right?
Yes.
Okay. And mom, did you used to live in Eureka?
No, ma'am. I lived in Whitewater, and then my landlord
Okay.
sold his house. I'm in Butler County still.
Okay, so, yeah, I remember Whitewater way back when the case was filed, so, all right. So that was in Butler County, that's how it
Yes.
ended up in Butler County.
Yes,
Okay,
ma'am.
all right. Now, Brian, where do you work?
Currently, I am not.
Okay, are you on unemployment, or are you on disability, or are you just in between jobs, or what?
In between jobs, I had a bunch of health issues that I had to take care of, and it just wasn't working the way it
Okay.
should have. But I'm getting back to where I need to be.
Okay. Mom, where are you, working?
I'm a quality inspector for the Department of Defense and NASA at DJ Engineering in Augusta.
Okay. So DJ engineering, so you just have a regular work week?
It's about 50+ hours a week, yes. But yeah,
Okay.
it's very lenient. I leave at 7:15 every day and drive Cheyenne to school, and I pick her up at 3:20. And then we go to all the volleyball games. So
Trying to figure out the best time.
I get off work at 4:30 generally, but
Yeah.
like I said, my job is very lenient anytime it is needed.
Well, I'm going to set it for all day.
Okay.
If we actually go to trial, we're gonna need all day.
Yes, ma'am.
I think probably December 30th is my best day for custody trial. Now, I'm going to touch base with you before that to see if you have retained counsel or decided to get counsel.
Okay.
Or if you've come to some agreement between the two of you that you decide that you don't want to have a custody trial. So you
Absolutely.
can advise me of that. So I will want to check on the status of things in November. And I think I would like to do that on Tuesday, November 25th at 4:00.
By Zoom?
That will be by Zoom.
Okay.
The trial will be in person.
Okay. And you said December 30th at what time, ma'am?
I'm sorry, 9 a.m.,
Thank
9
you.
to 5.
9 to 5. And then November 25th at 4 p.m., correct?
Yes.
Okay, thank you.
Did you get that down, Dad?
Yes, I did.
Okay. Now, the weekend should start this, let's see, let me look here.
She does have a volleyball tournament coming up on Saturdays. How would you like us to work that?
All right, well, hang on here.
Okay, yes, ma'am.
Okay, so what did I say? I said the first and third weekends of October. So the 4th and the 18th. And then the 4th weekend is just Friday and Saturday.
Okay.
So actually, it's going to start the 18th.
Okay, and we have a volleyball tournament that weekend from 9 a.m. to 3 p.m. The location has not been disclosed yet. It's to be determined because of,
Hang on.
okay.
So were you saying this weekend is the 11th?
Yes, and the 18th is the tournament. We have one more week of volleyball, and then that Saturday is, I need a calendar. I can't use my phone.
Okay, so there isn't a tournament on the 11th?
Hang on, I'm double checking, ma'am. Hang on. Let me look at the calendar.
They're having weekend tournaments through the school?
Just on Saturdays, it's a tournament. Yes, ma'am. So the 18th is a volleyball tournament from 9 a.m. to 3, and I am unknown of the location. And Brian has that schedule with him. Cheyenne took a picture and sent it to him. So it is a volleyball tournament on Saturday. So I would like to know how to work that.
Okay. Well, Brian,
And that's the last game.
Brian, I am thinking then that the weekend should, for just this month, because you haven't had time with her, that that you'll get the second weekend and the 4th weekend all weekend long.
Okay.
From Friday at 5 to Sunday at 5.
So the 24th and the 25th?
So the 11th and the 10th.
Oh, the 11th. So this weekend, I
The
apologize.
10th through the 12th. and the 24th through the 26th. And then in November, it will go back to 1st and 3rd, and 4th, just Friday and Saturday.
Okay.
So it'll go back to what the original plan was, just flipping it.
Okay.
And then the holiday schedule remains the same. Hang on. And the transportation in your current order says respondent shall be responsible for picking up the children at the beginning of her time, and petitioner shall be responsible for picking up the children at the end of such time, except for the 4th weekend of each month, in which case the party receiving parenting time the first half of said weekend shall be solely responsible for transporting the children. So I assume you still have copies of your court orders.
I
Yes.
do.
So all you have to do is flip that.
So he
So-
needs to come to my house to pick her up on Friday.
Yes, and
Okay.
then you,
We'll go to his house and pick her up on Sunday.
yes.
Correct.
All right, can you guys live with this for now as the court order and follow it without any more intervention from authorities? Okay?
Yes, ma'am.
Do not make plans for the weekend or have her make plans with her friends or anything else.
Absolutely.
Because she's not in high school.
No,
She,
ma'am.
her activities should be extracurricular and affiliated with the school, and everything else comes secondary to her family time with her family, including her father.
Yes.
All right. Dad, I would strongly suggest that you either have witnesses that say you don't consume alcohol very often or at all, and that you don't have an alcohol abuse problem through a drug or alcohol evaluation, or if you can disprove all of it, you're free to do that. If you do have an issue with depression or drinking, you've fallen on some hard times with work, hey, just get into therapy or treatment. And only you can decide, and only you and your wife know what's really going on. And I will leave it at that. As I stated, I am not prejudging anything, but I am suggesting if there is a problem, that it needs to be acknowledged and needs to be addressed. And I'm hopeful that just by prohibiting it, and if you don't have a problem, that it just simply won't be an issue. So I don't know, but I want to see things get back, or us get you back on a good path, both of you. So anything else that needs to come before the court today?
No,
I
ma'am.
don't think so.
I generally, if they're attorneys, I have them journalize whatever I order based on their motions. So that would be, Melissa, you filed a motion, it's been partially granted,
And I will get that served correctly to him.
and I would have you do an order that summarizes what occurred. But I doubt that you probably will get that put together, because our success rate with that with self-represented folks is not very good. So I will try to put something together and get it filed. I am going to be out of town for a few days, and we have a holiday on Monday where the court's completely closed. But I expect that you all will follow the oral, verbal orders that I made today until all of this can get on file, which may be the end of next week. Okay?
Yes.
Sounds
All
good.
right. If there's nothing further, we are adjourned.